upholds demonetization. So I'll be explaining the relevant information from both prelims and mains perspective. First of all, you need to know the Supreme Court said that there is no flaw in the center's decision making process regarding this particular demonetization. Now you should know from where the government gets its power. From where the government gets its power of demonetization. So the power lies in Section 26 of RBI Act. RBI Act of 1934. Now, before coming to the Supreme Court verdict, we should know what is mentioned in the Act. This is what is mentioned in the Act. It says, this section says, on recommendation of the Central Board, there is already a video on the Central Board of RBI. It has 21 members, and all those information regarding Central Board we have already covered. So, on recommendation of the Central Board, the central government may, by notification in the Gazette of India, declare that with effect from such date as may be specified in the notification, any series of bank notes of any denomination shall cease to be a legal tender. It means it is giving the power to the central government. The central government can demonetize any series of bank notes. Now here the Supreme Court said any means all. So there should not be any doubt. Any series means all. It can demonetize of any denomination. So this is the law. But here if you see carefully, it is clearly mentioned on the recommendation of the Supreme Court. On the recommendation of the Central Board of RBI. This is what the contention was raised by the petitioners because they lost it. They were saying, the petitioners were saying, Section 26 Clause 2 was breached because the proposal has emanated from the central government. This proposal of demonetization, it started from the central government. It's what they are saying. The petitioners were saying. Whereas the requirement is that the proposal should emanate from the Central Board. They are saying the proposal should come from Central Board, not from the central government. So this is one point where you can write in the critical analysis. If you are writing the critical analysis, you can write this point, and you can write, and this is a very much a legal point also. You have to mention this act and you have to write it should come from the recommendation of the Central Board, but it came or it was proposed or it was initiated from the central government. That is what they are saying. So this is one point you get a critical analysis, but that is not enough because in the positive part, so you have to write the RBI verdict. In the positive part, you have to write the RBI verdict because you have to support the government, because after all Supreme Court has said that decision was good, it is valid. How? The majority judgment, this is the majority judgment. It said that the two requirements of this section of RBI Act is recommendation and decision. Recommendation of Central Board, and the decision, the final decision will be on the central government. So this is one point you can write in the positives. Now there is another dimension to this also. Now what is the dimension? The dimension is the 7th schedule. If you see carefully the 7th schedule, entry 36, list 1 of the 7th schedule. Now Attorney General, who was representing the government, he pointed out this point. He said the central government has power to demonetize, and it is a constitutional authority as per the 7th schedule, list 1, entry 36. This is what. Now I'll read it out. This is on the strength of entry 36 of list 1 of 7th schedule of the Constitution. The central government is not just concerned with the financial health of the economy, but it is also concerned with the sovereignty and integrity of India, the security of the state, the defense of the country, its friendly relations with foreign countries, internal and external security, and various other aspects. of governance. On the other hand, the RBI or the bank is only concerned with regulation of currency notes, monetary policy, price stability and allied matters. So here if you see carefully, this schedule is giving a difference. RBI is only concerned about monetary policy, only about the financial health. But the government is concerned with the financial health and also with the sovereignty and integrity, the security of the state, the defense of the country. Now the government says, if we need to eradicate black money, fake currency, terror funding, etc., etc., it is necessary to demonetize the currency notes in circulation, because black money, fake currency, terror funding are nothing but it affects the security of the state, the defense of the state, the integrity of the state. So the government can take action. So this point makes the government decision valid back in 2016. The demonetization decision was valid. Now here also you can say the government has also a constitutional authority. Constitutional authority. So one is legal authority, RBI section part 2 of section 26 of RBI Act of 1934. One is constitutional authority. So two valid points you give in favor of the government, and in critical analysis you can point it out. The recommendation is also required. So it is kind of a very balanced thing, and the majority judgment was that it is valid. Fine. Now some extra point like here you can see the first demonetization happened back in 1946, second in 1978, and third in 2016. So 3 demonetization happened. So one more thing I need to specify here is one more keyword from this whole judgment. If you see, a 5-judge constitutional bench of the Supreme Court has rejected the challenge by 58 petitioners. 58 petitioners were there to challenge the validity of demonetization, but it was rejected by a 5-judge constitutional bench. Now here the keyword is constitution bench. Now what is a constitution bench? Now what is the origin? What is the constitutional provisions of constitution bench? So here comes the polity topic. So basically this is a economic topic, but the constitutional bench is a polity topic. First of all, constitutional bench is benches of a Supreme Court of 5 or more. Number 1, 5 or more judges. Now, from where come this constitutional bench concept came? Like from where, which article of the Constitution? It is Article 145 Clause 3. Now 145 Clause 3 article says the minimum number of judges should be 5 for 2 kinds of things. For constitutional interpretation cases, interpret, or interpretation of fact or law. Any case where the constitution, like it is required to interpret the constitution or any fact or any law, so that will be a constitutional bench will be set, minimum number will be 5. Second is any case or any thing under Article 143. Now what is 143? 143 is when the President wants any opinion from the Supreme Court on matters of any kind of public interest matters related to any constitutional interpretation or fact or a law. So the opinion can be taken from the Supreme Court by the President. For that cases also constitutional bench will be set up. This is what is mentioned in Article 145 Clause 3. Okay, fine. So this is the connectivity part. So as I said, this whole lecture, every topic, I'll try to connect the interconnected topics. So this is one of that topic. So it's basically a economic topic, but we connect it to a polity topic. So polity, so economic gets connected to polity topic. Okay.